Morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence, Holmes. I'm presiding judge and County Court at Law 2. This is Mr. Cook. He can have a seat over there in the jury box. Yeah, that's the guy I'm telling you about. Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today for what we call an arraignment on the initial court hearing. What that means is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and the options that you have concerning the case. Now, the case that you have in this court is a criminal case. We have a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Now, your felony cases are normally referred to as your most serious type offense. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive. Your misdemeanor cases are normally referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And again, when I use the term serious, I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the case. Now, for example, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. Now, if a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. Person is convicted of a second-degree felony, which is a little higher. The range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those type of punishments. Right? Now, misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. The Class C misdemeanor, the range of punishment is a fine only, and the fine cannot be above or cannot exceed $500. And those Class C misdemeanors are cases that start in the JP court or the city court. For example, not having your seatbelt on is a Class C, or speeding is a Class C. So those cases only come to this court if the person is found guilty in that court and they appeal the case, and then the case comes to this court. Okay? And if it comes to this court, the punishment range stays the same. Cannot exceed, it's a fine only, cannot be above or cannot exceed $500. Now, the next highest misdemeanor is Class B misdemeanor. Your Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine, which is jail time, confinement, which is jail time, or a fine. All right. Now, The next highest misdemeanor, or the highest misdemeanor, is a Class A misdemeanor. And the range of punishment for a Class A misdemeanor, minimum 0 days to maximum 365 days, which is 1 year in the county jail, or a fine that cannot exceed $4,000, or you could be given both such confinement and a fine. Now, you may be eligible for probation. There are two types of probation that a person can receive. One type of probation is called unadjudicated probation, and the other type is called adjudicated probation. Now, unadjudicated probation, we normally refer to as deferred adjudication. With unadjudicated probation, it does not result in a conviction on your record. So if you get on unadjudicated probation or deferred probation, you don't have a conviction on your record. And if you successfully complete it, the case will be dismissed, and you may qualify for what is called a non-disclosure. A non-disclosure basically means that your record is sealed to the general public. So the general public cannot go in and see that case. Now, the operative word that I used was general public, which means that the government can have access to it. But most of the public is the general public, so most of the public cannot have access to it. Now, the other type of probation, adjudicated probation, we call that regular probation. That's where a person gets placed on probation, they have a conviction on your record. However, if they successfully complete the probationary period, the court can do one or two things. Well, the court can grant what they call judicial clemency. Judicial clemency basically means that the court can set that conviction aside, and they will no longer have a conviction on the record. Now, in order to qualify, the person has to successfully complete the probation. There cannot be any time left on the probation, and they have to be discharged and let off the probation by the probation department. If those three things happen, then the court can set aside the conviction. Now, if a person who received judicial clemency gets another conviction later on, okay, then the case that they received judicial clemency on can be resurrected. It can be brought back up, revived, and used against them. And if they try to get a license with Child Protective Services, which is CPS, CPS can either deny giving them a license, or if they have a license, they can revoke or suspend the license. Okay. Now, the paperwork that you have in your hand, okay, I'm getting ready to go over that paperwork with you right now. Everyone should have a clipboard, okay? And on this clipboard, there are a couple of documents. Now, the first document that I'm going to go over is titled Judge's Explanation of Rights to Defendants Without Attorney. Everybody should be looking at this here document. Now, this document states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you would like an attorney but don't have enough money to hire an attorney, you may request or ask for an attorney to be appointed to represent you. And number three, you may represent yourself if you do not want an attorney to represent you. Now, the first paragraph under number three states that if you want an attorney, you have enough money to hire an attorney, your case will be reset. Reset means that you will be given another court date from today to give you time to hire your attorney. The second paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to you by the court. Now, in order for that to happen, you have to first fill out a financial questionnaire. The financial questionnaire that you have to fill out is a 3-page document on the clipboard, and it is titled Jefferson County Affidavit of Indigence. Looks like this. Okay? Not complicated. Only thing you have to do is fill out the first page of this document. And now this is only for people who would like a court-appointed attorney. If you never requested a court-appointed attorney, You don't even have to worry about this form. So if you want a court appointed attorney, you have to fill out the first page, and we're gonna give you time to fill it out. You don't have to fill it out right now. Okay? You don't have to fill it out right now. So you're gonna fill out the first page of this document. And then you're gonna go to the second page. The second page, you're gonna fill out the top portion that says defendant's oath. And then the middle portion, that says unsworn declaration by a defendant. Okay? The second page looks like this. Sometimes the pages are out of order. So the second page looks like this. So the second page, you can fill out the top part that says defendant's oath, and then the middle portion that says unsworn declaration by defendant. And then you'll stop. Okay. Now, the third paragraph, let's go back to that first document. Judge's explanation. I told you I'm gonna give you time to fill out the forms. You shouldn't be filling out forms. You shouldn't be filling out forms now. You should be listening. Okay. Now, back to the first form. Judge's explanation of rights to defendants without attorney. That third paragraph down here says that you may not speak to a prosecutor unless you first sign a written waiver. Now, this paragraph is only for people who would like to represent themselves. So if you represent yourself, you'll have an opportunity to talk to one of the three prosecutors. Prosecutors are assistant criminal district attorneys who works for the Jefferson County District Attorney's Office. And the reason why you would have an opportunity to talk to them is because you're your own lawyer. So just like your lawyer will be able to talk to them, since you're your own lawyer, you'll be able to talk to them. And you'll be able to talk to them to see if you can work out a settlement in your case. Now, when I say work out a settlement on your case, that's normally called a plea bargain agreement. Okay? And so if you would like to settle your case today, you have an opportunity to talk to one of these prosecutors about settling your case. All right. Now, the waiver that you have to sign for those individuals, now it's for only individuals who will be representing themselves. If you're not representing yourself, you don't have to worry about what I'm getting ready to say. If you're representing yourself, you'll sign this document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Okay? You just read and sign this document and date it. Okay. Now, if we're going back to the original form, everybody go back to the original form. This paragraph down here in block form. Well, paragraph down here in block form says that you should be aware that there are dangers and disadvantages of self. This is for individuals who will be representing themselves. It says that you should be aware that there are dangers and disadvantages of self-representation. Representing yourself and waiving your right to an attorney may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of firearms, housing and public benefits, child custody, immigration status for non-citizens, and employment. And the last paragraph, this last paragraph right here states, and this is for individuals who will be representing themselves, that says that you may change your mind at any time. If you decide to represent yourself, you may change your mind at any time and ask for an attorney to be appointed. So for example, let's say you decided that you want to represent yourself, and you decided that you talk to the prosecutor, and they made you an offer. You said, I don't like that. I want a lawyer. You have a right to do that. Okay. Now, down here, it states that in bold letters says defendant's choice, mark initials next to only one choice. Now, everybody is going to make one choice down here on the bottom of this document. If you would like to apply for a court-appointed attorney, if you would like to hire your own attorney, you will place your initials on the first line to the left. If you're hiring your own attorney, place your initials on the first line to the left. You're going to sign and date it, and then you through. You don't have to worry about these other forms. If you would like to apply for a court-appointed attorney, then you're gonna place your initials on the third line to the left. On the third line to the left, court-appointed attorney. Okay? You're gonna sign, date it, and then you're going to fill out the Jefferson County affidavit of interest. And as I mentioned, you fill out the first page. Go to the second page, you're gonna fill out the top that says unsworn, that says defendant's oath, and then the middle portion that says unsworn declaration by defendant, and then you stop. Now, for all those individuals who would like to represent themselves, you will place your initials on the fifth line at the bottom. It says that I waive my right to attorney, I would like to represent myself. You place your initials, sign, dated, and then you'll go to this form that says waiver of counsel, purpose of the interview, to plea or proceeding trial, and then read and sign and you're finished. Well, okay, before we go on, does anybody have any questions? Yes,
What do we do for pleading no contest?
okay, I just mentioned. Okay, I'm gonna mention it again. If you are representing yourself, that means you pleading no contest or guilty or whatever you pleading. You will place or go to this first form. You're gonna place your initials at the bottom on the fifth line, right here to the left. Okay, place your initial there, sign and date. All right. Once you finish doing that, then there is another form. Okay, I'm gonna give you time to finish that. Okay, now there's another form that's titled waiver of counsel. Looks like this here. Okay, you're gonna read that form, and then you will sign where it says defendant, and you will date it, and then you stop. That's all you have to do. All right, any other questions? Yes.
I didn't get a clipboard.
We'll get a clipboard.
You said he can get one.
Wait, we don't, who needs a clipboard?
Who?
Which one, you?
Yes.
Okay, now, you didn't have a clipboard, did you understand? Or did I have to go back home? You got it? Okay, anybody else? Okay, now, as I mentioned to you earlier, we'll give you time to fill out that, the form. Now, I mentioned to you that, I explained to you, the rights that you have as a defendant in a criminal case. Now, one right that you have besides the right to have an attorney, one other right, is your right to have a jury trial. Well, before we get to there, let me explain something to you. You have a right to enter one of three types of pleas. Now, you mentioned that young lady mentioned one plea earlier, okay? I'm gonna explain to you all the three types of pleas that a person can enter. You can enter a plea of not guilty. If you're in a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you are not fighting or you will not be contesting your charges. That's what that means. Okay? Now, if you enter a plea of not guilty, you have a right to have a jury trial. You have a right to have a trial, right? And you have a right to have a jury trial. Now, where those young men are sitting, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to the evidence, listen to the arguments of the attorneys, the state and the defense, and then they will deliberate in the jury room, and then they will decide whether to find you not guilty or guilty. You also have a right, if you don't want to say you want to have a jury trial, you have a right to have what is called a bench trial. And what a bench trial is a trial by judge only. The judge would be the judge and the jury in the case. Okay? So the judge will listen to the evidence, listen to the arguments of the lawyers, and the judge will apply the facts of the law, and then the judge will decide to find you either not guilty or guilty of the offense. Now, if you're in a plea of guilty or no contest, then your case will come before the judge in one of two ways. It can come before the judge by way of an agreed plea bargain agreement. Okay, what a plea bargain agreement is an agreement that you or you and your attorney have worked out with the state to settle your case. Let's say you spent 2 days in jail and the state is offering 2 days in jail, which means you won't have to serve any more time in jail because you'll be given credit for time served. Then that case comes before the judge, and the judge can do one of two things. The judge can accept it or reject it. If the judge rejects the plea bargain agreement, you can say, well, judge says you're not following the plea bargain agreement that I made with the state. I take my plea back. In essence, I'm not entering a plea of guilty and no contest because you didn't accept my plea bargain agreement. You have a right to do that. Now, if the judge follows the plea bargain agreement, goes along with the plea bargain agreement, and you decide, say, within 30 days that you would like to appeal your case because you think that, well, you was wrongly convicted or the court committed an error by convicting you, then you want to appeal your case, that is to have a higher court to look at your case, you have to get permission from the judge that followed the plea bargain agreement. Now, if the judge gives you that permission, your case will leave this court and go to another court, to the Ninth Court of Appeals, which is right above us on the 3rd floor. 4 judges up there, they'll review your case. They can do one of two things. They can accept, or they can grant or deny your appeal. If they grant your appeal, they can just simply look and say, you're not fine, you're not guilty. Or they can send the case back down to this court with orders. Now, if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas. And that is the Texas Court of Criminal Appeals located in Austin, Texas. You would have to file what we call a pro se petition for discretionary review. What that means is, pro se means you represent yourself. Okay? Petition for discretionary review, you're petitioning that court, you're asking that court to review your case, to see whether or not your appeal should have been granted or whether or not this court committed an error by convicting you. Okay, they can do one of two things. They can grant or deny your pro se petition. If they grant it, they can simply find you not guilty, case over. Or they can send it back to the Ninth Court of Appeals with orders or send it back down to this court with orders. Okay? Now, if they deny your pro se petition, at that point, your conviction will stand. Okay. Now, also, I said that you have a right to have an agreed plea bargain agreement, which means you have something to work out. But let's say you and your attorney talked to the state and you didn't like what they was offering. Okay, let's say you wanted probation and they offered jail time. Well, you can say, well, I want the judge to decide what my punishment will be. That's called an unagreed plea bargain agreement. You don't have an agreement with them. And so you bring that to the judge, and then the judge will decide what your punishment will be within the punishment range. All right. Now, the other right that you have is you have a right to have witnesses that come to court. That chair where the microphone is, we call that the witness stand. And what witnesses do, they can come to court and testify. They can testify for you or against you. If you're representing yourself, you can ask some questions. If you're a lawyer, your lawyer can ask some questions. We call that either direct examination or cross-examination. You also have a right to not call witnesses. That is, you can waive your right to call witnesses. Okay? Give up your right to call witnesses. And if you do that, that means that you will not be calling witnesses. does not mean that the state will not be calling witnesses, because they will be calling witnesses, okay? And, you also have what we call a Fifth Amendment right against self-incrimination. That means you have a right not to testify. The state, the government, the DA's office cannot force you to take the witness stand and testify against yourself. And somebody might ask, why not? Well, you have a Fifth Amendment right, but you also, they have the burden of proof. They have to prove you guilty beyond a reasonable doubt. You don't have to prove yourself guilty. Okay? And so you have a right not to testify. It's called the Fifth Amendment. It's in the Fifth Amendment of the United States Constitution. A lot of times we might watch television, see one of those law and order shows, and the television lawyer, go up to the person to ask them a question. Person, I take the fifth. What they're saying is that I'm exercising on invoking my Fifth Amendment right not to testify. So I'm not saying nothing. And you can't force them to say it. Okay. Now, you can waive or give up that right. If you waive or give up that right, that means that you will be testifying. Okay. Now, the other right that you have is a right, we call it the right to have discovery. Big word, that simply means you have a right to see what the state has and will be using against you. You have a right to have access to the file. You have a right to see witness statements, your statements, police reports, lab reports, photos. You have a right to see video recordings, listen to audio recordings, see instruments, documents, or whatever they have, whatever they're using to as evidence, you have a right to have access to it in order to prepare for trial. Now, you can waive or give up your right to have discovery as well. Now, if you waive or give up your right, that simply means that you would not be having access. Okay. Now, everyone that's here, charges have been filed against you, you've been arrested, placed in the county jail, you bonded out of jail, you get out of jail on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a percentage of the bond to get out of, you pay a percentage of a bond to a bondsman to get you out of jail, or you out of jail on what we call a PR bond or personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were simply released under your own personal recognizance. All right. Now, I've said that to say this. Every day that you spent in jail can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail, and let's say you talked to the you talked to the prosecutor, your attorney talked to the prosecutor, and they're offering to settle your case in a plea bargain agreement for you to serve 5 days in jail. You already served 5 days in jail, they offered 5 days in jail. That simply means you don't have to serve no more time in jail because you'll be given credit for the time that you have already served. Okay? So if they offer 7 days in jail, you serve 5 days in jail, you only have to serve 2 days in jail. Why? You have 5 days credit. We'll take 5 from the 7, 2. Now, if the state is offering fine and court costs, okay, every day that you spent in jail, you are credited at $100 per day that can go towards your fine and court costs. So if you spent 5 days in jail, that's $500 that you have as credit towards your fine and court costs. State is offering you fine and court costs of $500, you won't have to pay anything. Why? Because the time you spent in jail is already paid it off. Okay? Now, if they're offering fine and court costs of $700 and you have $500 credit, that means you only have to pay 2 because we'll subtract 500 from 700, that leaves 200. Now, if you'll be required to pay the 200 on the day that we dispose of the case. If you can't pay it, no problem. Why? Because the court can put you on what is called a payment plan. And you can pay it off in monthly installments, small monthly installments until it's paid off. Now, if you don't have a job and you don't have the income to pay it off, no problem. Because the judge can convert your fine and court costs to community service. And for every 1 hour of community service that you perform in a nonprofit organization, $12.50 will go toward your fine and court costs. That's almost like you making $12.50 an hour. Okay? And so it goes towards your fine and court costs. So if you work an 8-hour day, that's $100. That can go towards your fine and court costs. So in my scenario, if you did 2 8-hour days of community service, that's $200, and boom, you're taken care of. All right, now, everyone that's here, I need to make you aware that Jefferson County has a program where they will dismiss your case and you can get it wiped off your record. Okay, the program, and when I say Jefferson County, I'm talking about the district attorney's office. The program is called pretrial diversion. If you haven't been in trouble before, then what will happen, they can, if you want interested in the program, if you qualify, and in order to qualify, it has to be first time getting into trouble, cannot be for an offense involving unlawful carrying a weapon or resisting arrest, and you have to have an attorney to help you with the application process. You get into the program, they will dismiss the case. You complete the program, you can get what is called an expunction, which means this case will be erased, deleted, or wiped off of your criminal record. So if somebody goes back, you got your case expunged, they go back and look at the criminal record, it's not there. That case is not there because it's been expunged. Okay, now, if you're interested, just let us know, and then we could direct you to you could talk to somebody in the DA's office, one of the prosecutors about the case. About that program. Now, if you're a veteran of any one of the branches of the United States military, the district attorney's office has another program that's called Veterans Court. It's for veterans only. And what they'll do with that case, if you get into the program and you just have to be a veteran, get into the program, complete the program, they dismiss the case, and then you can get a non-disclosure where your record is sealed to the general public. Okay? This court, County Court at Law number 2, Jefferson County, Texas, has a program that God led me to start in the first 100 days of taking office in March of 2017. The program is called the Community Safety Initiative, usually called the CSI program. The program is designed to address the issue of what we call recidivism. When people commit crimes over and over, that's called recidivism. And so with that program, we have partnerships with local agencies. And one of the agencies that we have a partnership with is Spindletop. And we have individuals from here, from Spindletop, and from Jefferson County Sheriff's Department. They're going to come to you in a little bit and tell you more about the program that Spindletop has offered. Basically, what Spindletop would do, they can have what we call an interview either in our jury room, at their facility, or by telephone, whichever is convenient for you. Then they can do an assessment. Assessment is to determine what your problem may be. And then they can develop a treatment plan to address your mental health needs. Now, you do not have to be insane or incompetent to participate in the program. You can just merely suffer from anxiety or depression or any other host of mental illness. And they have the expertise and ability to address your mental health needs. Now, if you have issues with drugs or alcohol, well, Spindletop has a program, it's called ATAR, A-T-A-R. It stands for Addiction, Treatment, and Recovery. And we also have a partnership with our local drug and alcohol council that has a program that is called OSAR, O-S-A-R, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they'll do, they can do a screening, an assessment, and develop a treatment plan for either outpatient or inpatient treatment to address your drug or alcohol needs. If you're unemployed, or you might be looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE is an acronym or it stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas that you select, they will help you to get a job in the area that you trained in. And if you have not graduated from high school or you do not have your GED, they have a GED program where you can receive your graduate equivalency diploma. Now, all of these programs that I just mentioned are free. Does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we can address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. So I like to say that when you come to County Court at Law number 2 in Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. And we'll be happy to direct you to people that can talk to you about getting into these programs. And as I mentioned to you earlier, we have some individuals with Spinotop. We have Deputy Powell and Deputy Butler. They're mental health officers. They're going to come to you right now and just tell you just a little bit more about the program that they have to offer. And then after they come, we have Johnny, who is with Family Services. Family Services is have a program called BIP, that is intervention programs for individuals who have family violence cases. Then what they'll do, he'll tell you more about the program that BIP has to offer. So at this time, we have Deputy Powell and Deputy Butler.
Morning again. I explained, earlier, this program is all about, so it's paper that we need y'all to fill out, and we already completed those. Thanks. You can give them back to me right quick. I'm going to take.
I've already got I'm not like that, I'm not like that.
Oh, mental health professional, that's fine, I hang about you. He's not here this morning. So like I said, I'm not going to be contacting, we don't have a phone number on file, something. It should be about no contact with them. So the meeting, I'm trying to be here with you. Whatever's said between you and, the health professional is kept between y'all. Somebody else needs to know about this. Yes, ma'am, that's right, Chef, and I'm on there.
And I'll stay, on a point, or I heard you have to do a lot.
I'm all there in this.
Nobody is from last year. Please.
Everybody,
Yes, I did.
we already explained that to them, but we just close this right.
The lady was raising her hand in the middle, where the officer, she was raising her hand. Ma'am, you had a question? Okay.
I told you that.
Yeah, I'm gonna go over that paperwork with him. Okay. Okay. Okay, Mr. Stewart?
Thank you, Judge.
Okay.
Good morning.
Morning.
I'm Johnny Stewart. I'm the BIP Director at Family Services. BIP stands for Batteries Intervention and Prevention Program. Used to be called Domestic Violence Program. This program is an 18-week program. We have Zoom classes and we also have in-person classes. And this is for one of the pretrial diversion class programs. If you have a family violence charge first time, you are eligible to enter this particular program. Okay. We're about changing behaviors, and that's what this program is about. So I hold you accountable for, what you're in here for. What we're trying to do is prevent you from coming in here. Okay. I just left Judge Stevens' office. We have one of our guys just getting ready to graduate in 2 weeks. So it will not only help you in your family life, but it also helps you as far as preventing you from coming back to any court. Take advantage of this program if you're eligible, or if your charges are concerning the family violence. Okay. We have pamphlets right here on the edge. Also, we have some other pamphlets because we have other services such as that assist the victims. If you're a victim or you know some victims who need some services, take one of those calls. We also have the children's and the women's shelter. That's what families are about. We also not only helping the victims, we also have trying to help change behaviors with a purpose. Okay. Thank you very much.
Okay, thank you, Mr. Stewart.
Yeah.
Okay, now, ladies and gentlemen, that paperwork that you have, you're gonna be turning that in. We're gonna go over that paperwork, and then we're gonna call you up before the bench one at a time. We're gonna put you in one of 3 categories, either 1, the hiring attorney, 2, that apply for court-appointed attorney, or 3, to represent yourself. Now, if you need any help with the paperwork, just let us know just by simply raising your hand, and we have our court personnel, including myself, who will be helping you to finish that paperwork. Now, once we finish with the paperwork, then you'll be able to, like I said, be in one of the 3 categories. Now, if you need to use the restroom, there are 2 restrooms right outside of the courtroom, in the hall. And the men's restroom is in front of County Court at Law Number 3, which is right next door to us. Okay? The women's restroom is on the opposite side of the hall, in front of the 172nd District Court. Now, you'll be allowed to go out to use the restrooms. And then I tell people this here. Do not leave the courthouse. The case is not finished. Do not leave the courthouse. Leave the courthouse. You call your name. Guess what? Bond gonna be forfeited. Warrant gonna be issued for your arrest. You're gonna be arrested. And that's what? We're gonna have to go through all of this all over again. All right? And so it shouldn't take us that long to get everybody in and out. All right? And so if you need help, just let us know. Raise your hand, and then we'll be happy to help you. And then what we're gonna do, we're gonna call you up one at a time, try to get you in and out. Okay? And now, let me tell you this. If you apply for a court-appointed attorney, you will be appointed a court-appointed, and if you qualify, you will be appointed a court-appointed attorney today, before you leave this courtroom. Okay? If you're representing yourself, your case will be disposed of today, before you leave this courtroom. All right? All right. Any questions? If I have no questions, The other thing is, on that paperwork, there's a line and stuff within the state of Texas versus, it's just a line. Print your name there, don't write it in cursive, print it. Because sometimes we can't read, the cursive. Yes,
Are you, is it still the same where you have to take care of the billing before you take the lease meeting?
that's up to your attorney, how you wanna handle the case. Okay, there's no particular rule, okay? It's based on what your lawyer suggests, or, yeah.
Well, we're still we're about to hire a lawyer.
Okay.
Yesterday, she came to Eleni Court and they rescheduled it.
Okay,
So I didn't know if.
if you're hiring an attorney, if you hire an attorney, if that's what you want to do, if you hire an attorney, your case will be reset, meaning you'll be given another court date to give you time to hire your lawyer. That's what it said. Okay, anybody else? Yes.
At the last, you said if you're representing yourself, your case will be disposed of before.
You can get it disposed of today because you're
Oh,
gonna talk to one of the prosecutors, and if you accept their agreement and you wanna go to jail,
gotcha.
it'll be done today. Okay. Okay, anybody else? Yes. Oh, we got some white items.
Okay.
It's not a problem. Anybody else? Okay, so now let me tell you this, be mindful that we still in court. So let's not get too loud, and so we can get this process through, so we can go ahead on and finish with the process, okay? So at this time, the court will be in recess. If you need help with the paperwork, just raise your hand. Or if you finish with the paperwork, raise your hand, and then we'll come out and get the paperwork as well. Okay. Jefferson County Court at Law number 2 is back in session. Court is in session with its arraignment docket. First case is cause number 24 CCCR 2970. Case is styled the state of Texas versus Carol L. Crawford. Mr. Crawford, would you please come forward?
You just went to the restroom.
Right here, right here.
No, I'm doing the recess. Okay, Ms. Crawford,
Yes, sir.
your full name is Carol L. Crawford?
Yes, Carolyn Brown.
Okay, Ms. Crawford, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Ms. Crawford, you may put your hand down. How are you doing, Ms. Crawford?
I'm good.
That's good. Now, Ms. Crawford, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
Is this your signature on the line that's titled Defendant?
yes, sir.
And all these your initials on the line that state you'd
Yes,
like
sir.
to have your case reset to hire your own attorney.
Yes, sir.
Now, Ms. Crawford, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Crawford, your case is going to be reset to give you time to hire your attorney. Our court coordinator is going to give you a reset. Once she gives you your reset, you'll be free to go. Please have a seat in that first chair on the wall. Gotta move that chair back.
This one?
Yes, you can move it back to the wall. Thank you.
Thank you.
You're welcome. Next case is, for the next two cases, on cause numbers 25 CCCR 1052 and cause number 25 CCCR 1053. Both cases are styled the state of Texas versus Brianna Nicole Clannon. You let her know that door, see. Ms. Clannon, your full name is Brianna Nicole Clannon? Ms. Clannon, would you please raise your right hand? Ms. Clannon, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Clannon, you may put your hand down. How are you doing, Ms. Clannon? That's good. Ms. Clannon, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you would like, well, that you have already hired Ralph Kimball?
Yes, sir.
Now, Ms. Clannon, before you signed and initialed this document, did you read the document?
Mhm.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? Okay, Ms. Clannon, I read your response. Your case will be reset. Our court coordinator is going to give you a reset. Once your case is reset, you're free to go and you have a blessed day. Cedric Henry. Mr. Henry, your full name is Cedric J. Henry. Mr. Henry, please raise your right hand. Mr. Henry, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Henry, you may put your hand down. How are you doing, Mr. Henry? That's good. Mr. Henry, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to
Yes, sir.
apply for court appointed attorney? I have another document that is titled Judge's Explanation that actually is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a set of initials on a line next to the box that's checked defendant's signature. Is this your signature? Mr. Henry, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Henry, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Laura Perazzo. Attorney Perazzo will be given information to contact you, and you will also be given information to contact her. Our court coordinator will give you that information. But before she gives you that information, I need to give you some bond conditions. Ms. Bailey, would you hand these bond conditions to Mr. Henry? Okay, Mr. Henry, I'm going to go over these bond conditions. And the document is titled Standard Bond Conditions in County Court at Law Number 2. Following the return of a criminal information in County Court at Law Number 2, all bail bonds executed for release of any defendant named herein or order subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or against the United States. Do you understand that condition? Okay, condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. Court may revoke the bond and revoke. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test of drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol. And the test indicates the presence of drugs and alcohol in the defendant's body. You understand that condition?
Yes, sir.
Condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yeah.
Condition number 4 does not apply because that only applies in the DWI case. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Mr. Henry, do you understand that condition?
Yes, sir.
And if you violate any one of those conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that? Okay, now, Mr. Henry, please have a seat in that chair, that first chair on the wall, and wait for your name to be called. Okay? Yeah, you have a blessed day. Brent Fontenot? Now, Mr. Fontenot, before we get started, you have a right to have a court reporter to type down or dictate everything that's being said in this case. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up the right to have a court reporter?
Yes.
Okay.
If I'm assertive.
Now, Mr. Fontenot, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Fontenot?
Okay.
Doing okay? That's good. Fontenot, state is represented in this case by Attorney Shane Hilton. Attorney Hilton, how are you doing?
I'm good, Your Honor. Thank you.
That's good. Now, Mr. Fontenot, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney.
Yes.
You recognize this document? Is this your signature on the line
Yes.
that's titled Defendant?
Yeah.
Are these your initials on the line that state you like to waive your right to attorney and
Yeah.
represent yourself? I also have another document that is titled Waiver Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document? And is this your signature
Yes.
on the line that's titled Defendant? Now, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct
Yes.
to the best of your knowledge?
Yes, sir.
Mr. Fontenot. Let's see, I also have. Let's take a while. No? Okay, Mr. Fontenot, I have on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Brent Fontenot, on or about March 10th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Fontenot, do you understand what you have been charged with?
Yes, sir.
To this charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Okay, Mr. Fountain, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
This document is also labeled as State's Exhibit Number 1. On page 2 of this document, there are two sets of initials. First set of initials is on a line next to a box that's checked "Nolo Contendere," which means no contest. Did you place your initials there?
Yes, sir.
Second set of initials is below a paragraph that is titled Discovery Admonishment. And the initials are on a line that state, I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials in that location as well? Second location,
Oh, in the middle?
right here.
Yes, I wrote yes.
Okay. On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your
Yes.
signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes.
Is this your signature on the
Yes.
line that's titled Defendant? At the top of this document, there are two boxes checked. First box that's checked states that this is a plea bargain in case you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Fontenot, before you signed and initialed all these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the
Yes, sir.
best of your knowledge?
Yes.
Mr. Fontenot, are you a citizen of the United States?
Yes, sir.
State?
State offers State's Exhibit 1.
Okay, now, Mr. Fontenot, the state is offering State's Exhibit Number 1 to be used as evidence against you in your case. Now, State's Exhibit Number 1 is the same document that you previously acknowledged. This is the same document that have your initials in these two locations on page 2, and it has your signature at the top of page 3. Is it all right for the state to use this document as evidence in your case?
Wow.
Okay, no objections. State's Exhibit Number 1 will be admitted. Now, Mr. Fontenot, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Fontenot, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 90 days county jail, probated for a period of 12 months of community supervision. As for a fine of $200 with repayment of court costs and 40 hours of community service. And Mr. Fontenot does have credit for 1 day of jail time to go towards his fine and court costs.
Yeah, What's the court cost?
277.
Okay, Mr. Fontenot. The state is offering that you serve 90 days in jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $200, but you'll be given credit of 1 day toward that, 1 day credit toward the $200. So actually your fine will be $100. You'll be required to pay court costs of $277 plus probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15.
Can you slow down? That was a little fast talking.
Yeah, but I'm explaining.
I didn't understand the amounts.
Okay, I was gonna divide the amounts and tell you what you have to pay per month, but I'm gonna go back through it. Okay, you'll be required to pay $200 a month, but of the fine, but you won't be, not 200 a month, you'll be required to pay a fine of $200. But you have 1 day credit toward the $200, so that's $100. Your court cost is $277. Your probation fee is $60 a month. And your analysis fee is $15 a month.
15 or 50?
15.
Okay.
And your reimbursement fee is $15. Your total month installments, that is the total amount that you are required to pay each month, is $117 a month. Are you able to pay the $117 a month?
Yes.
You are? You'll also be required to perform 40 hours of community service and adhere to the other standard terms of this probation. And Mr. Fontenot, do you understand the state's offer? Do you think that the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Mr. Fontenot, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Fontenot, you're gonna stand next to the bailiff, follow her directions. Once you,
It's the lines behind you made my.
yeah, is there?
Yeah.
Yeah, but so once you finish following her directions, you're free to go and you have a blessed day. Katie Jagno. Ms. Jagno, your full name is Katie Michelle Jagno. Ms. Jagno, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Jagno, you may put your hand down. How are you doing, Ms. Jagno? I'm doing fine, thanks for asking. Now, Ms. Jagno, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you would like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Sir.
Now, Ms. Jagno, before you signed and initialed all of these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yeah.
Okay, Ms. Jagno, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information, but before she gives you that information, I need to give you some bond conditions. Now, Ms. Jagno, would you please step to my right, to your left? Gonna hand you some bond conditions. You can step back. Okay? Now, Ms. Jagno, the document is titled Standard Bond Conditions in County Court at Law Number 2. And it states as follows. Following return of accruing information in County Court at Law Number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
The defendant, now condition number 2 states the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. And the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply. That only applies in a DWI case. Your case is not a DWI case. However, condition number 5 does apply, and condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 of Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Ms. Jagno, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Please have a seat in that first chair and wait for your name to be called. Mr. Maglio Orchid.
I really don't understand why it's gotta be you all the time. Thank you. This is my courtroom. You didn't do that to him. Pay attention. Am I going to jail after this or something? That's not. That's not my bond, that's his. That's his. That's where he was going.
Okay.
That was his money.
Okay. Jefferson County Court at Law number 2 is in session, recorded in session in cause number 25 CCCR 1144. The case is styled, Mr.
No orchids, sir.
Maglio.
Just Maglio.
Okay, well, I have to pronounce what's on the paperwork, but you also
I
known
went to
as,
court and got my name back.
I understand, we have that all the time. The paperwork, documents is titled information. Is titled Misty Magliolo Orchid. You also known as Misty Magliolo, is that correct?
Now, the judge gave me my name back when I got divorced.
Okay, Ms. Magliolo, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
So, yes, sir.
You may put your hand down. Now, Ms. Magliolo, how are you doing?
Somewhat okay, right?
Okay, I understand that.
So I get a hold of my peer specialist.
Okay, now, Ms. Magliolo, I have before me on my computer. Well, first of all, Mr. Magliolo, before we go any further, you have a right to have a court reporter to type down everything that's being said or dictated everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter? Okay. Now, Ms. Magliolo, I have before me on my computer a document that is titled information. In this information, it alleges that you, Mr. Magliolo Orchid, on or about March 10 of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offensive criminal trespass. Do you understand what you've been charged with?
So, yes, sir.
And to this charge, how do you plead? Guilty, not guilty, no contest. So you pleaded no contest freely and voluntarily?
So, yes, sir.
And are you pleading no contest because you do not wish to fight or contest the
So,
charge?
yes, sir.
Okay, now, Ms. Magliolo, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
So, yes, sir.
Is this your signature on the line that's titled defendant?
So, yes, sir.
And are these your initials on the line that state you want to waive your right to attorney and represent yourself?
So, yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding in Trial. Do you recognize this document?
So, yes, sir.
And is this your signature on the line that's titled defendant?
So, yes, sir.
Excuse me. Now, Ms. Magliolo, before you signed and initialed these documents, did you read the documents?
So, yes,
Did you
sir.
understand what you read?
So, yes,
And
sir.
is everything in these documents true and correct to the best of your knowledge?
So, yes, sir.
Okay. Ms. Magliolo, I also have a document on my tablet. The first document is titled Misdemeanor Plea Admonishments.
So, yes, sir.
Do you recognize this document?
So, yes, sir.
This document is also labeled as State's Exhibit Number 1. On page 2 of this document, there are 2 sets of initials. First set of initials is on a line next to a box that's checked no contendere, which means no contest. Did you place your initials here? The second set of initials is below a paragraph that is titled Discovery Admonishment, and it is on a line next to a statement that reads, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials on this document?
So, yes, sir.
On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
So, yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
So, yes, sir.
Is this your signature?
So, yes, sir.
And at the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
So, yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
So, yes, sir.
Now, Ms. Magliolo, before you signed and initialed these documents, did you read the documents? Did you understand what you read?
So, yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Ms. Magliolo, are you a citizen of the United States?
So, yes, sir.
State Opera States one.
Okay, now, Ms. Magliolo, the state is offering State's Exhibit Number 1. That's the first document on this tab to be used against you in your case. Is it all right for the state to use this document as evidence in your case?
So, yes, sir.
Okay, no objection. State's Exhibit Number 1 will be admitted. Ms. Magliolo, are you a citizen of the United States?
So, yes, sir.
Okay, now, Ms. Magliolo, is there any evidence that you are currently mentally incompetent to stand trial? You understand what's going on with your case?
Sir, yes, sir.
Okay. Now, Ms. Magliolo, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange of defendant's plea of no contest, the state's offering 90 days probated over 1 year, $200 fine, and 50 hours community service.
I know not to use that bus stop ever again now.
Hey, 9001. 200. Any days credit?
Same as him, could have been.
Mr. Hugel, you want to apply on 1 day?
Yeah.
We'll apply the 1 day, Your Honor.
Okay, so she has 1 day credit. Okay,
You're gonna add that on.
yeah. Plus court costs. Okay, what's the court cost? Is it 277? Is it two, what's the, 720?
Shucks.
15. That's 13. And 2. Yeah, 2. Okay, where did she go? Miss, they need you to add this, yeah.
Here we go.
Okay, thank you.
You're welcome.
Remove that city bus stop for a time.
Okay,
That's not fair.
Miss Magliolo, the state is offering that you serve 90 days in jail, but you won't have to serve no time in jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $200, but you have 1 day credit that will go toward the fine of $200, which means the fine is $100 instead of $200. You'll be required to pay court costs of $277. Probation fee of $60 a month, your announcement fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $117 a month. Are you able to pay the $117 a month?
Sir, yes, sir.
You also be required to perform, is that 50 hours of community service?
Yes, Your Honor.
And you would adhere, now, you will also be required to adhere to the other standard terms and conditions of probation. Ms. Magliolo, do you understand the state's offer?
Sir, yes, sir.
Do you accept the state's offer?
Sir, yes, sir. I have no choice.
Okay, you have a choice.
No,
If,
not when it comes to my service animal, I don't.
okay, so my question to you is, and be mindful that you have a choice. Do you want to accept?
I accept.
Okay, so according to us, you'll follow the plea bargaining agreement that you have entered into with the state? Ms. Magliolo, did you redo it? Okay, just have a seat in that chair and wait for your name to be called. Once your name is called, you'll be free to go. You have a blessed day. Did I already do this? The Mario Hill? Good morning. Mr. Hill. Your full name is Demario Jannard Hill?
Yes, sir.
Mr. Hill, would you please raise your right hand? Mr. Hill, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Hill, you may put your hand down. How are you doing, Mr. Hill? I'm doing fine, thanks for asking. Mr. Hill, I have before me 2 documents. The first document is titled Judge's explanation of rights to defendants without attorney. You recognize this document? Is this your signature on the line as title defendant? Are these your initials on the line that state you would like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of the same document, there's a signature above the line that's titled defendant signature. Is this your signature? Mr. Hill, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Hill, I read your answers. Based on your answers to meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go, and you have a blessed day. You're welcome. This is hers right here. Elo Simpson. Who's that?
She went to the rest of the day.
Okay, next, Diamond Anderson.
Yeah, they both went to her.
Okay. Ruby Morrow.
This is 4,000 July. It's the last thing this is done.
Next case is cause number 24 CCCR 0562. Case is style of state of Texas versus Ruby Ivette Morrow.
Yes, sir.
Mr. Morrow, Ms. Morrow, is that your full name?
Yes, sir.
Ms. Morrow, would you please raise your right hand? Who's the prosecutor on that? Ms. Morrow?
Third.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Morrow, you may put your hand down. How are you doing, Ms. Morrow?
How you?
I'm doing fine, thanks for asking. Ms. Morrow, I have before me, prosecutor, attorney Andrew Hubel. And Mr. Hubel, how are you doing?
Doing well, Judge, thank you.
And Ms. Morrow, I also have before me on my computer a document on paper that's titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply
Yes,
for
sir.
court, that you would like to represent yourself, waive your right to an attorney? I also have another document that's titled Waiver of Counsel for Purposes of Inter Guilty Plea or Proceeding Trial. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Ms. Morrow, before you sign and initial all of these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes,
Is
sir.
everything in these documents true and correct
Yes,
to the
sir.
best of your knowledge? Ms. Morrow, before we go any further, you have a right to have a court reporter to type down or dictate everything that's being said. In your case, you also have a right to waive or give up your right to have a court report. Do you waive or give up your right to have a court report?
I give it up.
Okay, Ms. Morrow, I also have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. Hold on a minute. In this information, Ms. Morrow, it alleges that you, Ruby Ivette Morrow, on or about on January 30th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Ms. Morrow, do you understand what you have been charged with?
Yes, sir.
To this charge, Ms. Morrow, how do you plead? Guilty, not guilty, or no
No
contest?
contest.
Now, are you pleading no contest freely and voluntarily?
Yes,
And are you pleading no contest because you do not wish to fight or contest the charges?
that's right.
Okay? Now, Ms. Morrow, I also have before me on my computer a document that is titled misdemeanor admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, I do.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked no contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
There's a second set of initials at the bottom of this document, below a paragraph, that is titled Discovery Admonishment, and it is on a line next to a statement that reads, I do not wish request discovery. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials
Yes,
on this
sir.
document? On the next page of this document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Ms. Morrow, before you signed and initialed all of these documents, did you read the documents?
Yes,
Did you
sir.
understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Morrow, are you a citizen of the United States?
Yes, sir.
State?
Sit up for stage one.
Ms. Morrow, the state is offering State's Exhibit Number 1. This is this first document, the first document that you acknowledged. They offering this document to use as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes.
Okay, no objections?
No.
State's Exhibit Number 1 will be admitted. Ms. Morrow, is there any information that you're currently mentally incompetent to stand trial?
No, sir.
Okay, Ms. Morrow, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt, and also find that your waivers were freely and voluntarily given.
Yes, sir.
State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
The agreement in this case is to 90 days probated over 1 year with a $300 fine and 40 hours community service. The state is crediting 6 days jail time towards finding court costs.
40 hours to service.
Yes, 40.
Okay.
That's 40. What's the court cost? 277. So that's gonna wipe that out. Okay. 17. Okay, Ms. Morrow. State is offering that you serve 90 days in Jefferson County Jail, but you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you're required to pay a fine of $300 plus court costs of $277. But You will not be required to pay that because you have 6 days credit that will go toward the payment of your fine and court costs. So the 6 days is $600, which will wipe out your fine and court costs. All right, so you've already paid your fine and court costs by the time that you have served in jail. You'll be required to pay a probation fee of $6 a month. You're now to $15 a month, reimbursement fee of $15. Your total monthly installments for this case is $83 a month. Will you be able to pay the $83 each month? Okay.
Yes, sir.
Now, you will also be required to perform 40 hours of community service and adhere to the other standard terms and conditions of this probation. Ms. Morrow, do you understand the state's offer?
Yes, I do.
Think the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, sir.
Okay, I'll follow the
Thank
plea
you.
bargaining agreement that you have entered into with the state. Ms. Morrow, you will stand next to the bailiff, follow her directions.
And thank you.
Once you
Yes,
finish
ma'am.
following her directions, you're free to go. And you have a blessed day. Huh? Okay. Jeffrey Scott Pope. Okay, court is in session in 2 cases. They are cause numbers 25 CCCR 0001 and cause number 25 CCCR 0002. Both cases are styled in the state of Texas versus Jeffrey Scott Pope. Mr. Pope, is that your full name?
Yes.
Okay, Mr. Pope, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may put your hand down. How are you doing, Mr. Pope?
Good.
That's good. Now, Mr. Pope, I have 2 documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And are these your initials on the line that states you'd like to waive the right to attorney to
Yes.
represent yourself? And the next document is titled, well, not the next document, but on the next line is titled Defendant. Is this your signature?
Yes.
On the next document, that's titled Trial Court, that's titled Waiver of Counsel for Purpose of Entering Guilty Plea Proceeding Trial. You recognize this document?
Yes.
And is this your signature on the line? That's titled
Yes, I do.
Defendant? Okay. Now, Mr. Pope, before you sign and initial these documents, did you read the documents?
Yes.
You understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay. Now, Mr. Pope, you've had an opportunity to talk to the prosecutor in this case, and you have rejected that plea bargaining agreement. Is that
Yeah.
correct? Okay. So at this point, Mr. Pope, your options are you can one, continue to waive your right waive your right for an attorney and represent yourself, or you can apply for a court-appointed attorney, or you can ask that this case be reset to hire your own attorney. And so, do you still want to waive your right to have an attorney and represent yourself?
Yes.
Okay. Okay, now. Oh, here you go. Okay, now, Mr. Pope, I need to go over a document, it's called a Faretta warning, admonishment. It's required by the case of Faretta versus California, 422 United States Supreme Court, 806. And now, have you ever studied law?
Some.
Okay. Have you ever represented yourself in a criminal action?
No.
Okay. Do you understand the charges against you?
What are the charges against me?
Okay. These 2 cases were appealed from It's the city court, let's see. Hope. So. These cases was appealed from a Nederland Municipal Court?
One's
Yes.
expired registration, the other's for failure to control speed.
Okay,
No,
okay, let
Yes,
me,
Your Honor, that's what I'm
let me do this here, let me pull up the complaint. Okay, this is the complaint that was filed by Nederland Municipal Court. Filed in the Nederland Municipal Court. Okay, complaint, Jeffrey Scott Pope. Understands. Material. Okay. Display an expired motor vehicle that, okay, so the charges, this first charge is a display of an expired motor vehicle registration sticker. That's the first charge. Second charge, let me see. That's all one. And this one. Field controls. Okay, the second, the second charge that was filed by, Nederland let's see, it says that you fail to control speed of your vehicle. So it's a fail to control speed on this case, okay? So those are the two cases.
those aren't my charges.
Well, your name is Jeffrey Scott Pope?
I've got paperwork that indicates those are not my charges.
Okay, well, there was charged to a Jeffrey Scott Pope, all right? When I called Jeffrey Scott Pope, you was the one in the courtroom that came forward.
The paperwork I have has the exact same cause numbers with different charges. Do you mind if I show you the paperwork?
Okay,
Matter of fact, the paperwork was signed by the judge
Oh.
that I was guilty
Okay.
4 days prior to the
okay,
court
let me
date.
do this here.
That's illegal.
You'll have a chance to represent yourself. Now is not the time for your trial. You'll have a chance to represent yourself and you can put forth all the evidence that you need to defend yourself, okay? Okay, so, now, but do you understand the charges that I just stated?
I understand what you said. Yes.
Okay, now, are you aware of the, penalty range?
Of the what?
They're Class C misdemeanors. Are you aware of the possible penalty range, the possible punishment?
No,
Okay, a person, you could be given a fine that does not exceed $500.
okay,
Okay, these are Class C misdemeanors, as I mentioned in arraignment at a Class C misdemeanor, you cannot be given jail time. It's only a fine only.
Hmm.
Okay, now, do you realize that if you're found guilty, you can be assessed punishment anywhere within that penalty range?
okay.
Okay. Do you realize that if you represent yourself, you're totally on your own? I cannot help you in any way as the judge.
I understand that.
Okay. Are you familiar with the Texas rules of evidence and Texas case law?
No, not really.
And do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted, and in representing yourself, you must abide by those rules. You understand that?
Okay, where do I get a copy of those rules?
They are in the Texas code of, in the Texas rules of evidence.
Okay,
And there are books on Texas rules of evidence.
okay,
Okay. And now, and then Texas case law is all of the, there are volumes of
Mhm.
books on cases that
Right.
have been filed in Texas.
okay.
Okay, you would have to look those cases up that are applied to your case. Now, do you realize that the Texas rules of evidence, Texas rules of case law govern what evidence is admitted, and in representing yourself, you must abide by those rules? For example, how you conduct voir dire. Do you know how to conduct a voir dire? Voir dire, that means how you pick a jury.
Okay,
My question is, do you know how to conduct one?
No, I
Okay,
didn't know we did this process.
okay, well, okay. Now, do you know what are the grounds for excusing a juror for cause?
I know that you can excuse a jury for any reason.
Not necessarily any reason, but, do you know what is hearsay?
Mhm.
Okay. Do you know what are some of the exceptions to hearsay?
What was it?
Do you know what are some of the exceptions to hearsay?
What are some of the exceptions to hearsay?
Yes.
No.
Do you know what is proper impeachment of a witness?
No.
Do you know when and how to move for, to make proper objections?
Possibly.
Do you know when and how to move for a directed verdict?
No.
Do you know when character evidence are allowed in a case?
No, don't know what you mean.
Do you know how to offer evidence to protect the record for an appeal?
How to offer evidence? Yes.
Okay, that's to protect the record for an appeal.
Mhm.
Okay. Do you know the proper grounds for a mistrial?
I think I do.
Okay, are you aware that failure to timely move for mistrial may waive crucial mistakes made by the state or the court?
I do.
Okay. Do you know how to request and object to jury instructions?
No.
Are you familiar with the Texas Rules of Criminal Procedure?
No.
Do you realize that those rules govern the way in which a criminal action is tried in court?
Right, but this isn't a criminal action.
This is a criminal action.
How is it a criminal action?
Earlier, I mentioned to you during arraignment that the case that you have in this court is a misdemeanor case.
Mhm.
It is a criminal case. Criminal cases are divided into felonies or misdemeanors.
I thought traffic cases were not criminal.
It's a Class C misdemeanor.
Okay.
As a matter of fact, I think I said my example that I gave was a Class C misdemeanor was not wearing your seatbelt or speeding. Those are traffic cases.
Mhm. But
Okay,
those
so
are civil.
those are traffic criminal cases. You are in a criminal court. This case is a criminal court. Okay?
Okay, I'm not sure how we got to criminal when it's not a
Well-
criminal offense.
Yeah. Now, and I must advise you that it's my opinion that you will be better defended by a trained lawyer than you can by yourself.
A lawyer's first.
I think,
and-
I'm not finished. I think that is unwise for you to try to represent yourself. You are not familiar with the law. You're not familiar with the court procedure. You're not familiar with the rules of evidence. I would strongly urge that you not try to represent yourself. Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and give up your right to be represented by a lawyer?
Yes, a lawyer's
Okay.
first allegiance is to the court, not to the client. It's
So-
a scam.
Okay, well, okay, is your decision entirely voluntarily on your part?
Yes.
Okay?
And
And I
I'm
find that the
not a
defendant,
citizen.
okay, I find that the defendant has knowingly and voluntarily waived his right to counsel, and I would therefore permit him to represent himself in this proceeding, in this case. So at this time, Mr. Scott, your cases, or Mr. Pope, your cases are going to be reset. You'll be given another court date.
Right.
And the reason for that is, the case is gonna be set on what we call an announcement docket. And what an announcement docket basically means is that, when you come back to court, you can announce to the court, what you wanna do with your case. In the meantime, between now and announcement, you'll have an opportunity to have what is called discovery. And as I mentioned to you earlier on, what our discovery is, you'll have access to the district attorney's file to see, so that you can prepare for trial.
Okay.
Okay? And you can set up an appointment with the district attorney, office to have access to the evidence that they will be using against you in discovery, okay?
Okay.
And then when you come back to court for announcement, you can announce to the court whether or not you've had discovery or not. And if you haven't had discovery, that you need more time for discovery. And then we'll take it from there.
So we do this again?
Not this.
Well, I know.
No,
but
it doesn't.
something similar.
Well, not, no, no, it ain't gonna be similar. This is the arraignment. This is the initial setup.
Right, but how
Then we're
long-
gonna go to announcement. Announcement and arrangements are two different, like apples and oranges.
Right,
So you, in essence, you have to come back to court again. When you came to court today, your case is not set for trial today. Your case was only set for an arraignment,
okay,
where the court can tell you what you've been charged with, what your rights are, and what your options are. And
Okay.
that's basically what we did today.
hmm
Okay, so when we come back again, you'll be coming back for announcement. Okay, you can announce to the court, at that time, whether or not you had time or had access to the court's file, not the court's file, but the district attorney's file.
hmm
And then we'll take it from there.
And then after that,
Trial.
trial.
Yeah.
Okay. Seems like a lot of
Well, no,
wasted time.
that's, but like I told you, and like you explained, you're not familiar with the rules of criminal procedure. These are procedures that we are required to go through.
I understand.
Okay, so it's kind of like baseball.
Right,
We don't go from
right.
first base to home plate.
So let me ask you a question. In the trial, am I going to be able to see my accuser?
Oh,
The state of Texas
Oh,
is not
yeah,
my
you are.
accuser.
okay, well, you'll be,
It
well,
can't be.
when we get to that point, you'll have, all of your rights will be protected.
And
Okay.
and when I go, is this flag still gonna be fringed in the fringe? Because that's not
Well, that's,
an Article 2 court.
okay, well.
Am I
Everything
gonna
that you
be
see,
able to
everything
go
you.
to an Article 2 court?
This is everything that you see in this court is gonna be in this court.
Okay,
Okay, so-
but I have a right to go to an Article
Okay,
2
okay,
court.
well, whatever your rights are, you representing yourself, you can file motions. And the court will have hearings and then we'll make rulings. Okay, based on the law. So at this time, your case is reset. You're gonna get your reset from our court coordinator. Once you get your reset, you're free to go. And you have a blessed day.
You too, but I'd like
Thank you.
in the final trial.
Okay,
To be
we're not there yet. Okay, you're in arraignment right now.
I know you're
Okay.
not gonna do it like
Okay,
that.
well-
It's the problem.
Okay. Yeah.
Thank you.
Sorry.
I think
Okay, next case is cause number 25CCCR 1070. Case is style, State of Texas versus Diamond Anderson. Ms. Anderson, is that your full name?
Yes.
Ms. Anderson, would you please raise your right hand? Ms. Anderson, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Anderson, you may put your hand down. How are you doing, Ms. Anderson?
Good.
That's good, Ms. Anderson. I have before me two documents. First document is titled Judge's Explanation of Rights Defense Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes.
Are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And is this your signature on the line that is titled Defendant? Ms. Anderson, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Anderson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Marcus Wilkerson. Attorney Wilkerson will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go. And you have a blessed day. Please have a seat in that chair and wait for your name to be called. Kilo Simpson. Okay, hold on a minute, Mr. Simpson. Ronnie Green? Now, Mr. Green, I have two documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you'd like to waive your right to attorney and represent yourself? I also have another document that's titled Jefferson County Affidavit of Indigence. Actually, it's titled Waiver of Counsel for Purpose of Entering Guilty Plea or Proceeding to Trial. You recognize this document? Is this your signature on this document? Now, Mr. Green, before you sign and initial these documents, did you read these documents?
Yes, sir.
You understand what you read? Is everything in these documents true and correct to the best of your knowledge? Now, Mr. Green, have you talked to the prosecutors in this case? Okay, you hadn't talked to the prosecutors.
We spoke earlier, Your Honor.
Y'all spoke earlier?
Yeah. In regards to him having a felony case that was recently indicted in the same offense, given that at this point in the possible.
Okay,
effects
so-
that might have on this case.
So what he's saying, the prosecutor is saying that this case and a felony case occurred at the same time. And so the state is not in a position to make an offer to him right now in this case, is that correct?
That's correct.
Do you understand that? Okay, so now you still have a right to either represent yourself, or you have a right to ask for a court-appointed attorney, or you can ask that your case be reset to hire your own attorney.
Reset.
Okay.
I hired a friend.
You want to hire? Miss, could you have him to change his choice on that, and then his case will be reset?
I'll have to look at
Is that gonna strike through? Okay. Okay, so Mr. Green, your case is going to be reset to hire your own attorney. You can follow the bailiff. And you have a blessed day.
You got to reset.
She can do the reset. She gonna get, she said one moment.
No.
That's sure it is. Kilo Simpson,
Yeah.
Mr. Simpson, your full name is Kilo Denard Simpson?
Yes, sir.
Simpson, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Simpson, you may put your hand down. How you doing, Mr. Simpson?
Doing good. How you doing, sir?
I'm doing fine, thanks for asking. Mr. Simpson, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Now, Mr. Simpson, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Mr. Simpson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you give you that information, you'll be free to go. But before she gives you that information, the bailiff is going to hand you some bond conditions. And I'm going to go over these bond conditions with you. That you've just been handed these bond conditions. And it states standard bond conditions in County Court at Law number 2. And it states as follows. Following the return of criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 does not apply, and condition number 4 doesn't apply. However, condition number 5 does apply, and it states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that?
Yes, sir.
Now, Mr. Simpson, if you violate any one of these conditions, your bond will be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Mr. Simpson, you can have a seat in that first chair. Wait for your name to be called. Once your name is called, you'll be free to go, and you have a blessed day.
You too, Jeff.
Next case is cause number 25 CCCR 1140. Case is styled the state of Texas versus Takaya Armstrong. Takaya Armstrong was scheduled to be in court this morning at 9 a.m. At about 9 a.m. Court's bailiff called the name of Takaya Armstrong at the courthouse door. Takaya Armstrong did not answer. Takaya Armstrong has not been in court since the court's been in session. The time now is 12:14 p.m. on today's date of June 24th, 2025. Ms. Bailiff, would you please call the name of Takaya Armstrong at the courthouse door?
Yes, sir. Takaya Armstrong. Takaya Armstrong. North Carolina.
Takaya Armstrong name was just called again at the courthouse door. Takaya Armstrong did not answer. A reasonable time has passed to give Ms. Takaya Armstrong an opportunity to appear in court. Takaya Armstrong did not appear. State, do you have a motion?
Steve Booster Bumble.
That motion will be granted. Takaya Armstrong bond will be forfeited and warrant should be issued for Takaya Armstrong arresting cause number 25 CCCR 1140. Next case is cause number 25 CCCR 0462. Case is styled state of Texas versus Esteban Rivera Garcia. Esteban Rivera Garcia scheduled to be in court at 9 a.m. At about 9 a.m. Court's bailiff call the name of Esteban Rivera Garcia at the courthouse door. Mr. Rivera Garcia did not answer. And the time now is 12:15 p.m. on today's date, June 24th, 2025. Ms. Bailiff, would you please call the name of Esteban Rivera Garcia at the courthouse door? Esteban Rivera Garcia.
Escobar Rivera Garcia.
Yeah.
Esteban.
Yes.
Esteban Rivera Garcia. Esteban Rivera Garcia. No response, John.
Okay, Esteban Rivera Garcia's name was just called again at the courthouse door. Esteban Rivera Garcia did not answer. A reasonable time has passed to give Mr. Rivera Garcia an opportunity to appear in court. State, do you have a motion?
Steve Booster Bumble.
That motion will be granted. Esteban Rivera Garcia's bond will be forfeited and a warrant should be issued for his arrest. And cause number 25 CCCR 0462. Next case is cause number M333796. Case is styled the state of Texas versus Deneen Ashton Taylor. Deneen Taylor was scheduled to be in court at 9 a.m. this morning. At about 9 a.m., the court's bailiff called the name of Deneen Taylor at the courthouse door. Deneen Taylor did not answer. Deneen Taylor has not appeared in court since the court's been in session. The time now is 12:16 p.m. on today's date. Ms. Bailiff, would you please call the name of Deneen Taylor at the courthouse door?
Deneen Taylor.
Yes.
Deneen Taylor. Deneen Taylor. No response, John.
Okay. Deneen Taylor was just called. Name was just called again at the courthouse door. Deneen Taylor did not answer. A reasonable time has passed to give Deneen Taylor an opportunity to appear in court. Deneen Taylor has not appeared in court. State, do you have a motion?
Steve Booster Bumble.
That motion will be granted. Deneen Taylor's bond will be forfeited and warrant be issued for the rest of Deneen Taylor and cause number M333796. Next case is cause number 25 CCCR 0472. Case of Styles, State of Texas versus Tamir R. Thomas. Tamir Thomas was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the bailiff called the name of Tamir Thomas at the courthouse door. Tamir Thomas did not answer. Tamir Thomas has not appeared in court since the court has been in session. The time now is 12:17 on today's date, 12:17 p.m. on today's date, June 24, 2025. Ms. Bailiff, would you please call the name of Tamir Thomas at the courthouse door?
Tamia Thomas.
Yes.
Tamia Thomas. Tamia Thomas. No response, Your Honor.
Tamir Thomas' name was just called again at the courthouse door. Tamir Thomas did not answer. A reasonable time has passed to give Tamir Thomas an opportunity to appear in court. Tamir Thomas has not appeared in court. State, do you have a motion?
Steve Booster Bumble.
That motion will be granted. Tamir Thomas' bond will be forfeited and warrant should be issued for Tamir Thomas in cause number 25 CCCR 0472. Next case is cause number 25 CCCR 0442. Case of Styles, State of Texas versus Byron E. Williams Jr. Byron Williams Jr. was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Byron Williams Jr. at the courthouse door. He did not answer. He has not appeared in court since the court has been in session. The time now is 12:18 PM on today's date of June 24th, 2025. Ms. Bailiff, would you please call the name of Byron Williams Jr. at the courthouse door?
Byron Williams Jr. Byron Williams Jr. No response, Your Honor.
Byron Williams Jr.'s name was just called again at the courthouse door. Byron Williams Jr. did not answer. A reasonable time has passed to give Mr. Williams an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Favor to one.
That motion will be granted. Byron Williams Jr. name, bond will be forfeited and a warrant shall be issued for his arrest and cause number 25 CCCR 0442. And this will conclude the calling of the court's arraignment docket on June 24th, 2025. County Court at Law Number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Prosecutors, you are excused.
Enjoy.
You're welcome.